Well, good morning, and thank you to all of you who are participating in our administrative processes by both your written and your oral submissions. Today's administrative hearing is an essential part of that process and affords us the opportunity to hear from members of the public concerning matters that are before the court for our consideration. Our agenda for these periodic hearings is always available on our Michigan Supreme Court website as soon as they have been settled. While many participants speak on behalf of groups and organizations interested in particular matters, this process is, as always, open to any member of the public, whether he or she is speaking on behalf of an organization or simply to communicate their individual views. So once again, thank you all for being here this morning to offer your thoughts and to respond to questions the court might have. Whatever actions we end up taking on these and other matters, your thoughts will always be given serious and respectful consideration by the court. Each of you will have 3 minutes to speak, and now let us begin. Item 1, pertaining to erroneous judgments of sentence, we have the prosecutor from Livingston County, Bill Valancourt.
Good morning. May it please the Court. William Valancourt, Livingston County Prosecuting Attorney and also Vice President of the Prosecuting Attorneys Association of Michigan. Appreciate the opportunity to address the Court on this matter. We agree that there needs to be a modification to the rule. Pam has filed a written comment which defines specifically what constitutes an illegal sentence. We think that that would be an appropriate addition to the proposed rule. But I would also join in the comments submitted by the State Bar of Michigan supporting the amendments proposed by Tim Boffman. Mr. Boffman's approach delineates specifically between an illegal and an invalid sentence, and we think that that's the best approach and would encourage the court to adopt it. I'd briefly like to address Sato's comment, which says there should be some kind of a time limit or a good cause requirement for a party to file a motion to correct an illegal sentence like there is for 6500 motions. But the reality is that the way the 6500 rules work is that there is no practical limitation on a defendant seeking to correct a judgment that's illegal. If there is an illegal sentence imposed that prejudices the defendant, good cause is always going to exist for a 6500 motion by virtue of an ineffective assistance of counsel claim, because no competent defense attorney would fail to object to an illegal sentence that prejudices their client. The current rule works only one way. The defendant can seek to file a 6500 motion to correct an illegal or an invalid sentence, but the prosecutor has no ability to do so.
Mr. Valancourt, I read Mr. Boffman's letter as well, and he asserts that when we arrive at an illegal sentence that's enforced by the court or by the appellate court, he says that's something of an embarrassment. And I would tend to agree with him. But I'm not sure I agree with his remedy. For us to get to an illegal sentence, the court has to make a mistake, but also the parties have to not be paying attention to that mistake. So I don't mean to pick on you, but since you're here, does your office have a protocol for reviewing judgments of sentence to make sure that there aren't any mistakes or errors? What we tend to see in the appellate system is apparently everybody's offloaded this responsibilities to the Michigan Department of Corrections, and they're not a party to a case, but they have this amazing power to come in at the end of a case after it's done in an ex parte fashion and change the result of the case, to change the judgment of sentence. And now you're saying they should be able to do it at any time they feel like. The defendant could be released, he could have served his sentence, he could be at home on his back deck having a lemonade, and under your remedy we would pick him up again and say, nope, you got an illegal sentence and there's a mandatory minimum and you're going back to jail.
Well, I think that at sentencing, first of all, what prosecutors in my office and around the state would try to do is make sure there is not an error at the sentencing proceeding, that the prosecutor advises if there's some defect. Defense counsel has the same obligation, and the court does as well. So the best scenario is for it to be identified at sentencing, so we don't get to this situation. I recognize the circumstance that you've identified, and perhaps something that would be appropriate to add is that, and I think it was something that the State Bar Criminal Jurisprudence Committee looked at as well, is a limitation stating, well, you can't correct it after the defendant has already completed the terms of their sentence and been discharged from probation or
Let me
parole.
put a finer point on the question. Why isn't 6 months enough for the prosecutor's offices around the state of Michigan, the Attorney General's office, to review a judgment, a sentence, to determine whether there's a mistake?
Well,
Whether it's illegal. When you say it's illegal, I mean, somebody should figure that out at some point in time, shouldn't they?
well, the 6-month time frame, though, really applies only to prosecutors. Defendants can always come in and correct an illegal sentence.
Our system is set up to give defendants a lot of rights that prosecutors don't have, right?
Right, but I'd agree with Mr. Bloffman's observation that it really is embarrassing that a valid and lawful sentence was...
Who should be embarrassed by this?
Well, I think the system as a whole. I think judges, obviously, they should know the law, prosecutors should know the law, defense attorneys should know the law. And if something is omitted at sentencing, it should be pointed out at the time of sentencing.
Is it too much to ask the prosecutors to figure that out within 6 months after the judgment of sentence is entered?
Well, it's a duty that imposed on everyone. The court should know the law as well as defense counsel.
Well, I mean,
Everybody should.
Everybody has incentives, right? We have an adversarial process. The defense has an incentive to find out if there's a mistake that prejudices the defense, right?
Yes.
The prosecutor's office has an incentive to find out if there's a mistake that prejudices the people of the state of Michigan and the crime victims who are affected by these crimes, right? So my point is, in that specific, you're here, I think, because you're making sure that defendants are being sentenced appropriately according to the law and serving the full extent of the sentences they should be serving. I assume you're not here because you're trying to make sure they serve less time.
Well, if the court imposes an illegal sentence that is longer than mandated by law, yes, we point that out. And there have been circumstances where we've identified errors that prejudice the defendant. Defense counsel or the court hasn't, but we come to the court and say, you need to fix this.
I understand, but I mean, your point is well taken that the defendant has lots of remedies for when that happens, when the sentence is illegal
Right.
and it prejudices the defendant. We're really here talking about just sentences that are illegal and prejudice the people. And my question is, the people are involved in the case, they initiate the case, they, on the information, state what the sentence is, they are there at sentencing, and presumably could even have a process after sentencing, like the MDOC does. Why isn't 6 months enough time for all that to happen?
Well, if you look also, I mean, the Comer case is kind of interesting because there was an underlying legal question as to whether or not lifetime electronic monitoring applied. And it required this court to make the decision under some competing Court of Appeals decisions. So the judgment may or may not actually have been invalid. It's after this court made its decision in Comer that we all know, okay, the law is lifetime electronic monitoring in every CSE1 case. Well, so then there are judgments out there that are contrary to law, and there's no interest that really says, well, a defendant gets a windfall. They get a benefit of an illegal sentence after the law has been decided by this court as to what applies. Yes, in a perfect world, all these errors would be identified at sentencing, but the fact that errors occur...
I mean, the federal system, they give, only 14 days, and somehow they abide by that very strict limitation. So I just, in my mind, and I obviously was involved in proposing the rule, 6 months is an appropriate period in our system, which is larger and has a higher volume and higher error rate probably than the federal system, to find these mistakes. I'm just not, as you can tell, not persuaded that more time than that is needed. I do think it's reasonable to give the participants in the system a reasonable opportunity to do this. My sense of it is we're not getting a lot of effort from the prosecutor's side to identify these errors. Instead, we rely on the MDOC, and once they point it out, then you're here saying, okay, someone else pointed out a mistake, now we should be able to fix it. And that seems like not really the way to run a railroad to me.
Well, like I said, in a perfect world, everything would be identified at sentencing, and the only issue you would then have would be clerical errors. But the reality is that there are things that are missed by, the judge has the obligation to impose a legal sentence regardless of what the parties say. And if the court misses something, that's something that should be corrected regardless of if the parties point it out.
Any further questions?
Sorry to monopolize your time.
That's why I came here.
Okay, well, thank you, Mr. Valencourt.
Thank you very much.
We'll see you later this morning, won't we?
Yes, thank you.
Okay. Is there anybody on item number 2? Item number 3?
I don't know, because I only have the one.
Item number 4, Alan Gershell, the Administrator of the Attorney Grievance Commission.
Good morning. May it please the Court again, Alan Gershell on behalf of the Grievance Commission. My comments are really brief as to this agenda item. The Commission is requesting that the Court delay adoption of either Alternative A or Alternative B and wait until the ABA has completed its review of all of the advertisement rules, including 7.1, I think, through 7.4, at which time it would be our position that we would be submitting a proposal that would embrace 7.2 as well. However, if the Court's inclined to move forward on this, it's our view that the Court adopt Alternative B. It appears to be more expansive than Alternative A. It seems to encompass more sophisticated kind of advertising. And the only other change we would suggest is that excluding the phrase law firm in the rule, I think by just keeping the name of the lawyer, it gives better protection for the public. So again, to repeat, it's our position that we would request that the Court delay an adoption of either alternative until the ABA has completed its work on the advertising rules.
What do you think of the hybrid, rule proposed by
You
Mr.
talked a
McGill?
lot on the last rule, I'm just saying. Go ahead.
All right, go ahead. I just curious.
Well, I was going to ask the same question. What do you think of the hybrid proposal that's on the table? And why wouldn't we do something now and then we could revisit it in 6 months when the ABA does something else? I mean, why put off providing more protection to the public in the meantime?
As I said, I think Alternative B is a better version and would be our recommendation. I think in terms of efficiency, I think it's more efficient to do this as a one-step process and not a two-step process. But if the Court is so inclined, we believe that the B version is a better version. It's broader and will encompass more of the kinds of advertising that we are seeing.
Is it your expectation that there are likely to be changes in the current proposal at the next convention?
I think that certainly will be, a small example, but if you look at 7.3, I think it's 7.3, it talks about solicitation by telegraph. Now, we don't see many of those cases anymore, so that rule is pretty antiquated and could use revisions, and so that's our view.
Any further questions?
Why is this such a concern?
I'm sorry, Justin.
Yeah, good morning. Why is this such a concern? Why is this something that the bar is so concerned about?
Advertising?
Yeah. Why is this? This seems to be kind of a focus, and I'm just curious if you could help us to understand as to why this is such a concern.
Well, we get a lot of requests for an investigation on advertising cases.
Okay.
And find those cases difficult cases because you're balancing, as the Supreme Court has said, the ability under the First Amendment to advertise. And unless that advertising is patently false, there's really not much for us to be able to do. I mean, we sort of chip around the edges on some of these advertising cases when we can establish some degree of falsity. Solicitation is a different matter.
Right.
It's obviously very different, and we'll pursue those cases. But we struggle with the advertising cases, and perhaps when we see what the new ABA model rules look like, it may help us in terms of our enforcement responsibilities.
But I guess my question is, like, if you have in the medical community, you see the ads for 1-800-DENTIST. I mean, why, I mean, I see that ad constantly. So I guess my question is, if you're looking at this 1-800-DENTIST, and I guess you have, I'm not really familiar with a lot of the ads that we're like dealing with here, but I guess your concern is you have an ad where it's just like a number or something that doesn't identify the firm, correct?
Yes, I think it should, again, if the alternative B is adopted, we would just recommend that law firm be taken out. I think the consuming public is better protected when we know who the lawyer is who is handling the matter.
Right. But if you were to call, I'm just trying to give an example. So give me an example of what you're concerned about.
Well, I'll give you a couple of examples where we have taken some action in advertising cases, if that would be helpful. We've had situations where a lawyer will place on his or her webpage, John Doe and Associates. And there are no associates. That's a patently false advertisement.
Okay.
Or another example was the attorney advertises offices all over Michigan. There's one office. That's false.
Right.
It misleads the public.
Okay.
So, you know, those are kind of easy cases, and frankly, once we identify those cases for the lawyer, they've been very quick to make the change. We've not had to file formal complaints. We say, this is false, you need to change your advertising, and it gets done quickly because they know what the alternative is going to be.
Right.
So those are the easy cases.
Right.
When it's clearly false, it's the other stuff that makes it more difficult.
But give me an example. I'm trying to understand this better myself. Give me an example of something that's more complicated that you're looking for guidance on.
Best PI lawyer in Michigan. I mean, how do I prove that's false? I mean, I don't know if that person is or is not, or they're advertised as an expert in criminal defense. I don't know if that's, you know, that's true or not.
So what would you like us, I guess my question is, and this is helpful, this conversation that we're having, so thank you for engaging me in this.
Yes.
But I guess my question is that what would the alternative, so someone says they're the best attorney in Michigan, right? That's your concern, right? Like a lawyer, because you're not supposed to compare yourself to other lawyers, correct? Is that the idea? Like you can't, so someone says we're the best in this area, right? So that, I guess you're saying that's kind of a concern. So what you would want the court to regulate that, to basically say that you can't say that you're the best?
No, I'm not advocating that. I'm not advocating that at all. I think that would be problematic.
Okay.
We would have huge enforcement issues. We would have huge proof problems. And frankly, I could devote the whole office to investigating cases like that and not do the more serious stuff. So, Justice Bernstein, I'm not advocating that. And if I suggested that, I apologize. That was not my intent. I just find those cases very difficult, and lawyers have a First Amendment right to advertise.
Right.
And so unless it's false, I don't know what, at this point in time, what we can really do. I am curious to see what the ABA comes up with. They've been evaluating this, and I think it might be helpful to the process. So I guess I'll end where I started with a recommendation to hold off, but if not, again, we would recommend B as being more expansive.
Okay, but your issue is that basically, you know, at this perspective is you just want the court to be more concerned if it's a patently false statement, right? So going back to the issue of, you know, we have offices all over the state and you have one office. If it's a patently false circumstance or situation, you want to be able to rein that in. But in terms of the other First Amendment issues that come with advertising, you don't want the court to get engaged in that conversation.
I just think it's a much more complicated issue and has to be done case by case. I don't want to paint with too broad a brush here.
Right.
But I think that by and large, that has been our touchstone in the Grievance Commission before we take on those cases, because I'd have to convince a panel of lawyers judging this lawyer that this advertising was false.
And that's the standard. The standard now is your concern is just falsity, not any of the other.
That's our focus at this point in time. Before again, I'm separating solicitation from advertising.
No, solicitation is a whole different thing.
Exactly.
We're talking about TV, radio, that kind of thing. So your focus, or the current focus right now is that basically lawyers have a First Amendment right to advertise, to express themselves, and ultimately, unless they say something that is patently false.
Or false. Okay.
I'm sorry?
False.
False.
Yeah.
That they say something that is false, then ultimately the First Amendment would trump any other concerns that people might have as it regards to that.
Speaking from my perspective as the enforcement arm, I think to bring those cases would be very, very difficult as we stand here right now.
Okay. Thank you very much.
Thank you, Mr. Gershon. Our next witness will be Attorney Jules Olsman.
Good morning. May it please the court. I am here in my individual capacity to support the alternative A to 7.2. I do sit as a member of the State Bar Board of Commissioners, and I am not here to speak on behalf of the State Bar. I saw that our executive director sent you a comprehensive letter which lays out the position of the bar. My concern, and this has been almost 4 years now in the making, to get these 53 words into 7.2, is I want to, this should be entitled the Who Are You Amendment to 7.2. That's all it asks. Who are you? Who are you? If you're going to run an ad, you're going to run a website, you're going to have a billboard, it should say who you are.
Counsel, I have a question. Counsel, why is the public not able to figure that? What is your concern here? If I call you up, who answers the phone? If I'm calling a phone number, what is the concern that you have? If I
don't know that in all circumstances, Justice Bernstein, but I do know that there are websites out there, and I'm not, in the written comments that went to the court by myself and others, I'm not looking to single anyone out. But if you look up, if you Google Gold Star wages or Gold Star law, there's no names. Who are you? Who are you?
What happens when you call them?
I don't know. I've never tried.
But
What's the number?
Right, let's call them now.
You want to give them a call right now?
I mean, let's give
You know
it.
I'm going to as soon as I get
I assume that. But the purpose of the rule is transparency and providing information to the public. We don't sell hardware. We're selling legal services to people who need help. And I believe it's only reasonable that if people are going to do that, they're going to put their names on billboards, they're going to put their names in ads, or an icon name. We're not talking, when this originally started, the people that came out strongly against it at the Representative Assembly, I think it was either 3 or 4 years ago, were the large firms like Dickinson and Dykema and Honigman. They said, well, we advertise under a trade name, so we don't think it's necessary if we put an ad in a magazine that says Honigman or Dykema that we need to put anything else underneath it, because if you Google Dykema, boom, there's the website, there's everybody's names, there's everything they do. The same is true, Justice McCormick, in her questions, which all of the people who responded seemed to focus on correctly, raised the question about 1-800 law firm. That's absolutely fine. If you Google 1-800 law firm, you will get their whole website with all the lawyers who work in the firm and exactly what they do.
So, Counsel, your concern is that this is like a mystery, like people call these numbers and there's no, I guess what I'm trying to understand is that if you call these numbers and then someone answers the phone and they say this isn't the follow-up question usually who are you? What I'm trying to understand is how does this all work? If I were to call that number and say how do they answer the phone? They say this is.
Well, that depends on what they are, Justice Bernstein. So, for example, a few years ago, you may recall that there was a series of billboards on buses all over the city called Motor City Accident Attorneys.
Yes.
And I kept asking people, who are Motor City Accident Attorneys?
Okay.
Nobody seemed to know. Now, that's a whole other issue that other states are looking at now, including Illinois, and that's these case brokering services like Fort Payne and things like that, which are national outfits that are out advertising. They have huge budgets, and then they're diverting legal services. They're diverting cases to lawyers who are willing to either pay. I don't know what they do. I hope to God after 40 years in the profession, I'm not going to find out what they do and how that works. But that may be another issue, and that may be another issue for another day. It may not even be an issue for this court if they're not law firms. Or how are you going to regulate that kind of service?
Is this analogous to the 1-800-DENTIST, where I call 1-800-DENTIST and then 1-800-DENTIST then sends me to someone, or they refer you to like a dentist in your area? Is that how they would work?
That may be the case, but the idea is simply to identify who the entity is that is running the ad. I mean, we're not here, I'm not here to talk about whether lawyer advertising is good or bad, because it doesn't matter, it's here to stay. And it's a multi-billion-dollar industry across the United States. I'm not here to talk about that. I don't really care what the ABA is going to do, with all due deference to my colleague, to Mr. Gershell. I'm interested in the State Bar of Michigan. I'm interested in the consuming public, the people who will go to a lawyer because they need help. And I think before you even dial 1-800, for whatever, you should have some idea who that is. So if you see a name, let's just see an icon, nothing but an icon. There's a huge billboard up on Greenfield and 10 Mile in Northwest Detroit with just a picture of an attorney on it, nothing else, and it says wins. That's all. Who is this? I mean, what is this? What's the harm in that person or that law firm putting their name on that board? So you know who you're calling.
Mr. Olsman,
Yes.
I've heard you this morning, and I guess I wonder what's inadequate in your view about the current ABA model rule?
I don't believe that there's adequate protection for the public by what's out there today, at least in terms of what we've had in Michigan. I'm not prepared necessarily to discuss all the nuances of the ABA. I'm interested in the Michigan rule. And in putting this thing forward, there were many people involved, including Professor Sedler at Wayne State, to deal specifically with the issue of First Amendment considerations. And his position is when you give people more information, it's hard to argue it's constricting their First Amendment rights. We're not asking people to take information out. We're just saying, just tell us who you are. It's a simple matter of transparency, and it's a simple matter of just telling people who's paying for the ad.
Okay, I think your time is up.
Well, actually, counsel, I guess my question is, just to be very clear, this is your only concern is this issue in terms of the fact that you want to, for these different entities, when you call them, you just simply want to know who the person is that's running this specific entity.
That's correct. I want to know who it is. That's exactly right. Who are you? That's exactly correct. To assure that the entity purporting to be a law firm or purporting to be a lawyer is in fact a lawyer, is in fact licensed in Michigan, and is an identified entity, not an icon, a symbol, or somebody masquerading as a lawyer or masquerading in that capacity in order to get the case to give it to someone else.
Isn't that fully accomplished under the model rule?
I do not
In fact,
believe so.
even when there's no icon or symbol, it requires that there be a public communication of who's responsible for the advertising.
I believe, with all due deference, Justice Markman, I believe that the small number of words that are involved here would take care of, no, if you say to me, well, can I point to a specific example? Of course not. But I see the potential for harm. I see grave potential, and that's what I'm here to try to seek prevention of.
Thank you very much.
Thank you
Mr.
very
Olsman.
much.
Wait, before you go, your submission says you support either alternative A or alternative B, and I guess my next question is, in that order?
Well, in my written submission, I just said either one will be fine, but in reading the comments of Mr. Tucker and Ken Mogill and the other people that responded, and in hearing the debate with the Board of Commissioners, I think the best alternative is alternative A.
And what do you think of the hybrid alternative proposed by Mr. Mogill?
I think that my preference would be A. I think that there's ways to nuance this thing all the way around. I think somebody might say, well, what if we put in this, or what if we put, I just think we need to put in who is providing the legal services. And the problem, and Norm Tucker points out correctly in his letter to you, that the more you leave the door open, the more somebody's going to figure out a way to go through it. So if you just say, okay, just the name of the lawyer paying for the ad, that may not necessarily be who's providing the legal services. So I think the broader and more encompassing approach is the better way to go.
Why is this such a problem now? Has this been going on for a while?
Well, I mean, attorney advertising has reached warp speed proportion now, especially with the internet now. I attended a conference in Chicago last week where one of the sponsors is a company that does the metrics of attorney advertising, how much it costs literally to get a call, how much does it, and I mean, it's becoming a refined science to the likes of which I've never seen. But Justice Bernstein, there are ads out there that don't have names of lawyers in them, of people purporting to be law firms. And if there's one person that's misled, it's too many. And like I said, I can't point to an empirical study that would tell the court that there have been X number of complaints or anything like that. I have no way to know that. I'm here to try to prevent that from happening. If it prevents it from happening to one person, it's been worth the last 4 years' effort talking and being involved in this.
I guess the one concern is that, is there going to be other things to come? Like, what I'm trying to do is bifurcate your issue from the overall general issues of freedom of speech and the other things that we've been discussing this morning. Is your issue specific to this discussion, or will we be seeing, are we going to see more issues to come, or is this it?
No, I am here to be specific, unlike what I usually am. We are not here to talk about all the nuances of attorney. I'm not attorney advertising, whether it's good, whether it's, who knows? I mean, like I said, it's here to stay. It's here to stay, and it's omnipresent. The question is, this just deals with one thing and one thing only. Just tell us who you are.
And I'm not taking a position. I'm just trying to understand all the angles. But what I'm trying to understand is, what is the distinction between what happens in the medical field when I don't know who's behind 1-800-DENTIST, but that's who people are calling to find out who they can go to in their area. So how do you distinguish, dental work or medical work from legal work, and why should one be, and I'm just asking this in a general sense, why is it that one should be more regulated over the other?
Well, that's a good point, but I don't know what the Dental Association requires of its members, and I don't know what the Medical Association requires of its members.
But the same issues are relevant, because you're basically talking about your issue and concern, and you're doing a great job, and we're grateful that you're here with us today, because I think you're helping to explain the issue quite well. But both issues deal with the safeguarding of the public. So,
but I just looked up 1-800-DENTIST. I'm just telling you, I didn't know about it. I just looked it up, and it's actually a referral service. It's not an advertising. You go to 1-800-DENTIST and you put in where you live, and then it finds you a board-certified dentist with a name in your area. So it's not. I'm not sure these are analogous.
So let me ask you a question then. Let's use that as a model. Let's say you called up this number, it's 1-800 whatever.
1-800 Lawyers Help Me.
Lawyers Help Me, and then they were to refer you to a lawyer in your area. Would now that be okay, or is that?
The Bar Association does that.
If they're not a law firm and they're a case broker, I don't mean to say case broker in a pejorative way.
So just to be,
they're advertising secretly.
Maybe no other way to say it, though.
I understand, Jill. Counsel. So basically, what you're saying, counsel, is that your issue is just what Bridget was saying, is that it's
different. Apples and oranges.
They're different, and you just want to know who it is that's behind the ad, to be very clear as to who's making the ad, so when people call, they know exactly who they're speaking to and what representation they'd be getting.
That is exactly all. It just seems like a small thing. So.
Okay.
All right.
Thank you, Mr.
Thank you very much.
Sorry,
Appreciate it. Thank you.
Item number 5, Mr. Gershell, you're also interested in testifying on this?
As to this matter, Agenda Item 5, we would support the change that we include spouses in the list of individuals that we would have to recuse ourselves from hearing a case on. So I have no objection to that at all.
What would be your view about expanding the list of relationships that would fit within the modified rule?
I don't think it's necessary. I don't think it's necessary. I think that, at least speaking from my own experience at the Grievance Commission the last 4 years, we've had one case that involved a complaint against the spouse of an employee, and we've had 2 cases where the complaint involved the spouse of an ex-commissioner. And it was my decision that, although it wasn't required, that we recuse the office from handling this case. So I don't think it happens very often. I think when it does happen, we use good judgment and err on the side of recusing ourselves. And so I think adding a list of relationships that would be covered by the rule, I think is a solution where there's not a problem, frankly.
Any further questions?
Thank you.
Why don't you stay here? We also have you in number 6.
All right, as to number 6, it's the position of the Grievance Commission that this change is not necessary. I understand that the proposal is an outgrowth of the Townsend decision, but I think there are a sufficient number of protections in place already. For example, 1.4b requires that a lawyer explain the matter to a client. 1.16 also deals with this issue. So I'm also stepping away from my current position. Before this, I was a prosecutor for 30 years, and I don't recall a single situation where this issue came up. So again, I could be wrong, but at least in my experience and as well with other prosecutors, I don't think it's a systemic problem, and I think that the rules we already have address this issue. The attorney would have to go to the court and get the court's permission. The attorney has to otherwise speak to the client, discuss the problem with the client. So frankly, I think it's an unnecessary rule.
Okay, thank you, Mr. Gershell. We also have scheduled on item number 6, Attorney Joshua Blanchard.
Good morning. May it please the court. So I am a criminal defense practitioner. I'm also the incoming chair of the criminal law section and a director of CDAM. So I think I'm pretty well immersed in the day-to-day practice of criminal law. And my primary objection to the current rule and why I encourage the court to adopt the model rule is that it gives the lawyer, the criminal defense lawyer, too much control. It gives them a trump card in the attorney-client relationship. Because any time a client says, I don't want to take this deal, the lawyer can threaten to withdraw to coerce a plea. It's my view when you get into a criminal case, you're in for the duration. The court recently adopted limited scope representation rules and specifically excluded criminal from that. If we adopt the rule that says, well, you just got to tell your client that you have to seek permission from the court before you can withdraw, I think that tacitly endorses the practice of threatening withdrawal to get your client to plead. And it sort of moves us toward this limited scope where a lawyer can say, well, I'm only going to get in for plea negotiations. And if that doesn't work, I'll tell my client, well, if you don't plead, I'm getting out. I don't think that's the way our criminal justice system is set up or should be set up. And so I think the solution here is to adopt the model rule that gets rid of the imprudent standard, doesn't let a lawyer out of a case because he thinks the client is making an imprudent decision. I mean, the client's the one who has to suffer the penalty if he's wrong, and so I think it's his right to make that decision. If the court adopts my proposal and adopts the model rule, I would encourage the court to also provide clarity to the bar that threatening to withdraw over rejecting a plea offer isn't appropriate. I don't think that's a practice we should be encouraging, and so I'd ask the court to make that clear if it adopts the model rule. Thank you.
Thank you, counsel. Item number 8, Alan Gershell.
Thank you. As to this item, we support the concept. My only recommendation on behalf of the Commission is that we expand the time period. I think it's 56 days currently in the rule, and our recommendation is to go to 180 days. And my reason for this is as follows. In a number of cases, when we have decided to decline or reject a request for investigation, we set up a process in the office where the complainant can ask for reconsideration of that denial. And the way the system is set up is that that request will be reviewed by the Deputy Grievance Administrator. It's a de novo review. It means we reopen the whole case. We may do some additional investigation. And in some cases, the initial decision to close the case is in fact rejected, and we open the case. Even if we still close the case at the end of the period, and it does take some time to do this, At the end of the day, it still may be helpful to the court that we did this, because if the person does seek review by this court, our reconsideration review may help to clarify some of the issues that you'll be asked to review on the reconsideration. So again, we support this. We would just like a little more time to facilitate our internal review process.
We'd like to divide things by 7 without remainders, so you'd be okay with 182 days? With
Yes,
that?
yes, yeah,
Okay.
exactly.
Don't leave again,
Okay.
please. We have you on number 10 as well.
Okay,
Would you like to introduce yourself again?
yes, again,
I think it's a good idea because I want to know who the lawyers are.
I also think some of my colleagues behind me are going to address this agenda item as well. As we have indicated in our letter, we support this rule in its entirety. It makes very good sense that we clearly delineate situations where there's a prospective client talking to a lawyer. This better protects the client. It also better protects the lawyer. He or she knows what their responsibilities are as it concerns potential conflicts. And frankly, this is a rule that we have no problem with. And I think it's needed, and it'll give additional protection to the public. So we support the rule. Thank you.
Thank you, Mr. Gershell. Thanks for all of your testimony this morning. The next witness on the same subject is Stephanie LaRose of the State Bar Professional Ethics Committee.
Good morning. May it please the Court. I'm the current chair of the Michigan State Bar Standing Committee on Professional Ethics, and I'm here representing the State Bar's support for the adoption of proposed Rule 1.18 on prospective clients. The reason that we support this rule, and that also the Attorney Grievance Commission does as well, is that we are the people on the ground with the ability to ascertain whether lawyers are struggling to understand and comply with their duties toward prospective clients. A review of issues, complaints, and former ethics opinions would indicate that attorneys are in need of greater guidance on that issue. We have at least 4 prior ethics opinions addressing prospective clients or attempting to address prospective clients under current rules, which largely do not address the pre-engagement period. Those opinions are quite lengthy. A lot of analysis is needed to come to answers that are very simply stated within the proposed rule and the comments to that rule. And so it is for that reason that we support the rule. Additionally, the rule is verbatim ABA's model rule 1.18 and the comments to it. The ABA adopted that rule in 2002, and in the 16 years interceding, approximately 30 other jurisdictions have adopted the rule, either the same rule or substantially similar. And in that period of time, a review of the literature, ethics opinions, and cases that have arisen under those rules does not indicate any substantial concern, controversy over the rule, or difficulty in applying it. And for that reason, we support the proposal, which is word for word Model Rule 1.18 and its comment.
Thank you very much, Ms. LaRose.
Thank you.
Our final witness of the day will be Mr. Valancourt again on issue number 11.
Thank you. May it please the Court again, William Valancourt, Livingston County Prosecutor and Vice President of the Prosecuting Attorneys Association. Appreciate the opportunity to be here. We support the proposed rule with 2 amendments as outlined in Pam's letter. First is a stylistic change. The second is a substantive requirement that the discussion about mistrials occur on the record. Frequently, there's a lot that goes on off the record or in chambers and areas other than mistrials. But I think it's especially critical in this area involving a mistrial that a record be made of the parties' positions on whether a mistrial is appropriate. It facilitates, I think, better decision-making in the trial courts, but also creates a record to be reviewed on appeal. So we would support the rule with those amendments. I'll invite any questions.
Okay, well, thank you.
Thank you.
Thank you to all our participants today who've commented orally and in writing, and as I said at the outset, we will take your comments into very respectful consideration as we decide what to do on these matters. Thank you again. We stand adjourned.